Hope everyone is doing well. We are going to have 2 bill hearings today, and we will just go ahead and get started with Senate Bill 244, and I will have our reviser, Jason Thompson, give us a bill brief.
Thank you, Madam Chair. Good afternoon, committee. As you mentioned, Jason Thompson, Revisor's Office, Senate Bill 244, as amended by Senate Committee of the Whole, prohibits a compensated surety from making loans for certain portions of the required minimum appearance bond premium. The statute we're in here is KSA 22-2809B. That's the statute about regulation of compensated sureties. It's over in the Criminal Procedure Code in Chapter 22. I note in the brief, you can see in current law subsection D that there are requirements for a compensated surety related to charging a minimum appearance bond premium of 10% under current law. In addition, before posting the bond, the surety has to receive at least 1/2 of the required minimum premium, either by cash, check, credit card, debit card, or bank or wire transfer. That's all the current law there that you see on page 3. In addition, the surety has to enter into a premium financing agreement for the unpaid minimum appearance bond amount. So the changes relate to those items I just mentioned. First, the bill adds that a surety shall not provide a loan for the portion of the minimum appearance bond premium required before posting the bond. Also, that they shall not be an owner in whole or in part or affiliated with a financial institution making loans for the portion of the minimum appearance bond premium. I also noted that as introduced, the bill would have added that any loan obtained for the purpose of paying the required portion would be obtained from a financial institution that is properly licensed in Kansas, but that was the Senate Committee of the Whole amendment, was to remove that provision. And you can see that strike of the italic language on page 3. There was a proposed amendment, and that was removed by the Senate Committee of the Whole. The last thing I'd say is the bill would take effect on July 1st if adopted, and it passed the Senate 37-3. Be happy to answer questions.
Okay, thank you, Jason. Committee, do you have any questions for the reviser? Okay, thank you. Appreciate it. I'm going to do a little different order for the proponents today. I'm going to go ahead and call up Shane Rolfe from the Kansas Bail Agents Association. Thank you for being here in committee. You'll just introduce yourself. That would be great.
Start that again. Okay, my name is Shane Rolfe.
Yeah.
I'm the Executive Vice President of the Kansas Bail Agents Association, and I'm here to offer testimony in support of Senate Bill 244. As the reviser indicated, the bill that was passed last year, Senate Bill 473, requires the bonding company to collect at least half of the required 10% up front. What we're getting reports on from some of our members is there are some bonding companies that are trying to circumvent that by essentially loaning someone part of that money. Say, I'll just give you an example. You have a $1,000 bond and you're supposed to pay the bonding company at least $100, of which $50 has to be paid up front. The bonding company takes $20 out of their pocket, hands it to the person, they turn around and give them back that same 20 plus 30 and go, well, we've met that $50 requirement. We think that circumvents the intent of the statute of the bill that was passed last year. And this basically just closes that potential loophole. I don't think it's, quite frankly, I don't think it's permissible now to do that, but it's not explicitly impermissible. So adding this in there makes it explicitly impermissible to do that, to try and get around the intent of the legislature from last year's bill. It's pretty basic. If anybody has any questions about it, I'm happy to answer them to them, but it's pretty simple. This one is anyway.
Okay, committee, do you have any questions at all for Mr. Rolfe? Representative Carmichael and then Representative Martinez.
Thank you, Madam Chair. Mr. Ross, why shouldn't I just consider this entire scheme to be nothing more or less than an anti-competitive restraint of trade by the bail bonding industry?
Well, you certainly could consider it to be that way. Well, I would disagree with that. I mean, I think you've seen in Mr. or you will see in Mr. Breitenbach's testimony that the scheme that was proposed last year that passed is having the desired effect. The average bond amount in Sedgwick County is coming down. You know, you're not seeing these astronomically high bonds there, which was the goal. The judges were seeing that these discount bonds were being done, and so they continued to set bonds higher and higher and higher, making it more and more difficult for people to get out. And so I think what you're seeing, and I believe his testimony in the House reflected that this is working, and they don't want to see a reversion back to the way it was before. And if we don't close this loophole, you're going to see it just simply revert back to how it was before.
Representative Martinez.
Thank you, Madam Chair. Um, So the compensated surety shall not provide a loan for the portion of it. What would be the penalties for the compensated surety if in fact they do provide the loan? I mean, what's the oversight on that? How can you tell if someone's doing that?
The bill, the statute 22-2009B has several prohibited acts that the surety cannot engage in. The penalty for those is either permanent or temporary suspension of your ability to continue in business. The agent or the agency, I guess agency is not the right word, but the official that's empowered to make that decision is the chief judge of each judicial district. They're the same person that has the authority to authorize the bonding company in the first place. There is language in the statute as it exists now. The chief judge can assign someone to investigate a claim. So if they get a claim that this has occurred, they can assign, you know, someone in their office, another judge, ask the sheriff's department. They can assign someone to investigate that, give a report back to the chief judge. Once that report is back, the chief judge can make a decision about that. And the chief judge can suspend you. If that suspension is longer than 30 days, the chief judge needs to have a hearing detailing the violation and how long that suspension is going to last. It could be a permanent suspension. It could be a temporary suspension. It is at the discretion of the chief judge.
Thank you.
Committee, do you have any other questions for Mr. Rolfe? Okay, thank you very much.
Thank you, Madam Chair.
I'll now call Senator Stephen Owens. Welcome back to our committee. You see Representative Bourgeon has taken over your seat.
I hope you're representing well, Representative.
Yes, he's doing a great job.
Fantastic. Yeah, I come back. I'm grateful to be back here. I won't lie. I really miss the work that we do on Judiciary and miss that I don't get to have that pleasure on the Senate side, but needed elsewhere. I don't have much to add. I am grateful. One of the things that I like to do in full disclosure is let people know that this is an industry in which I've operated for better than 25 years and had the opportunity to work with proponents, opponents, and everybody on solutions to the industry challenges. And so want to let you guys know that I offer up my expertise if any of you have any questions.
Okay, thank you. Representative Carmichael has a question.
Thank you, Madam Chair. Senator, I appreciate you being here today. I read in your written testimony, and I'm looking at the second bullet-pointed paragraph. Unfortunately, there are compensated sureties that have chosen not to follow the letter of the law. If that's the case, why hasn't your industry gone to the chief judges, pointed out that bail bond agents are acting in violation of the letter of the law, and requested that the chief judges impose the sanctions that Mr. Rolfe just described a moment ago?
Fair question, and that is because we weren't very clear in the letter of the law, which is why this legislation is needed to make this portion of the law very, very clear, which kind of goes against what I said. They're not following the letter of the law. Well, we weren't good in explaining that in the legislation that passed last year, and this gets to that very specific point so that they would be able to do so.
And so that I accurately understand your position, then, Senator, I should strike that second bulleted paragraph from your testimony because it's just simply inaccurate. Is that correct?
I would say that you could strike the word "the letter" because the law, as Mr. Rolfe spoke to, does not, it's very clear on what is permissible, but it is not clear on what is not permissible. And so it is not quite that clear. So if you want to remove the letter, I think that would be appropriate.
Madam Chair, I'm not sure what the difference is between the law and the letter of the law, but we'll just leave it as it is. Thank you.
Representative Esau.
Thank you, Madam Chair, and welcome back, Senator. So I was looking at that, and it said that in the Senate Committee of the Whole, there was an amendment that made it so it didn't have to be a Kansas bank. Could you fill us in a little bit on that and why that was?
Yeah, so the concern was brought up in the committee of the whole. What if a family member wanted to lend money to the defendant or a friend? They were concerned that language as written might make them fall into that. And so it was easier just to strike that and pull that out for clarity purposes.
Thank you.
Committee, do you have any other questions for Senator Owens? Representative Schreiber.
Thank you, Madam Chair, and welcome back. And I probably should have asked Mr. Rolfe, but you might have some experience on this too, what the impact of last year's law with lowering the bond amounts and so forth. Was it just in Sedgwick County, or has it been seen statewide, that sort of thing?
There's no doubt that the primary crux of the problem has existed in Sedgwick County, and we have definitely seen that impact there. I believe Mr. Rolfe will be testifying on the next piece of legislation as well, and I'm sure he'd be happy to address that. He's much more familiar with Johnson County.
Okay, committee, any other questions for our proponent? Okay, thank you so much. We appreciate it. Committee, I'll draw your attention to 2 written-only testimonies. Sheriff Jeff Easter from the Kansas Sheriff's Association, and also Aaron Breitenbach on behalf of Mark Bennett, the DA in Sedgwick County, or the 18th Judicial District. So take a look at those. There are no opponents and no neutrals. And with that, I'll close the hearing on Senate Bill 244. And I'll open the hearing on Senate Bill 157 and ask Jason once again for a bill brief.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. Senate Bill 157, as amended by Senate Committee, requires warrants issued for failure to appear to be provided to a compensated surety. It also changes the criteria for setting aside bond forfeiture, and it requires remission if the defendant is returned to custody in certain circumstances. The statute, similar to the one in the last bill, is in the Criminal Procedure Code. It's KSA 22-2807. This is the one that governs forfeiture of appearance bonds. We note that current law in subsection A requires that if the defendant fails to appear and is charged with a felony, the sheriff enters that warrant into the National Crime Information Center's index. The bill, as amended by the Senate Committee on Judiciary, would add that the court is required to make a copy of the warrant available to a compensated surety who deposited the bond on behalf of the defendant. As introduced, it wasn't clear exactly who would make that warrant available, although the way the way the sentence was phrased, it was the sheriff. And the amendment makes clear that it is not the sheriff, it's the court that will make the copy of the warrant available to the surety. The next thing is current law in subsection C, which is near the bottom of the first page, provides that the court shall direct that a forfeiture be set aside. And the phrase is, upon such conditions as the court may impose, under a list of circumstances there. The bill strikes that phrase about the conditions as the court may impose. And the bill as amended, you can see a small amendment there in line 31 and 32. The bill as amended provides that the court shall direct that a forfeiture be set aside if the surety can prove that the defendant has been deported from the United States. Current law, allows that forfeiture if the surety can prove that the defendant is incarcerated somewhere within the United States. And this would add proving that the defendant has been deported. That would lead to forfeiture. Finally, in subsection C there and onto the next page, the current law provides for forfeiture if the court finds that the defendant has been arrested outside of the state and the prosecuting attorney has declined to proceed with extradition. The amendment in the bill is to remove the part that requires the defendant to be arrested. So the provision there near the top of page 2 would just provide that the prosecuting attorney has declined to proceed with extradition. So the arrest part is stricken. The last amendment in this statute and this bill is subsection E. There's a new provision added at the bottom of the bill. After entry of judgment, the court may currently remit in whole or in part after they apply the forfeiture setting aside criteria that's up above in subsection C. But the bill would provide that the court is required to remit 95% of the amount of the appearance bond to the obligor if the defendant is returned to custody within 180 days after judgment is entered. So right now, there's a permissive mechanism for some remittance, and this would add a mandatory remittance of 95% if the defendant is returned to custody within 180 days. Make that a little clearer the second time I said it there. This would take effect on July 1st if adopted, and it looks like this passed the Senate 31-9. Be happy to answer questions.
Thank you, Jason. I do have a quick question. So can you just go over again section D? Because I don't see it exactly in your bill brief, and I was not sure about section D. Could you just explain that a little bit?
Madam Chair, you're talking about the subparagraph capital D that's on
No,
page
the-
2, or?
The parentheses little d on page 2, line 11.
Oh, the current law. Yeah, I don't think I talked about it at all. So let's do that. So like I said, the amendments are in subsections A, C, and E. Okay, so let me refresh my memory about what D is exactly here. When a forfeiture has not been set aside, the court shall on motion enter a judgment of default, and execution may issue thereon. Boy, that's fun criminal procedure language right there. If the forfeiture has been decreed by a magistrate and exceeds the limit, notify the chief judge, okay. There is a small change to the word forthwith to promptly. That's kind of technical drafting updates that we're doing in the code, as is the herein to in this section.
Okay, that's probably what I was wondering. Those were just sort of technical things that you always do as
Yeah.
you're changing an amendment.
Yeah, and I apologize. I didn't even mention
Okay.
those, but yeah,
Just wanted to make sure.
Our editor is big on the forthwith becoming promptly, and herein becoming more specific, in this section, in this subsection.
Okay.
Trying to get away from some of that legalese that we used to use in statutes and use
To
more,
confuse people, now we can make it more.
trying to make it a little more user-friendly. You can thank Brian Garner and those of his like for trying to modernize our statutory language. Yeah.
Okay, good. Thank you for explaining that. I appreciate it. Committee, what other questions do you have? Representative Carmichael first.
Thank you, Madam Chair. I also noticed the other day that we're actually getting back to using fewer instead of lesser. Is that to be blamed on Mr. Gardner, or is that your good work along with the Oxford comma? I withdraw my question, Madam Chair. Thank you.
Okay, committee, any other questions for our revisor? Okay, I don't think so. Thank you, Jason. Appreciate it. All right, we have again 2 in-person proponents. I will call Shane Rolfe from the Kansas Bail Agents Association. And if you'll just introduce yourself, thank you for being here again.
I think I've got the mic on this time. All right. Thank you, Madam Chair. My name is Shane Rolfe. I'm the Executive Vice President of the Kansas Bail Agents Association, and here to offer testimony on in support of the bill. Probably going to do this a little bit differently than I normally would, because we have obviously, this bill was heard on the Senate side, and there were opponents at that point in time, and we've been discussing with the opponents potential changes to this. So I want to talk about what the bill does, and then what some of these proposed changes that we've sort of worked out with the opponents on this do. And I'll take this, as I see it, there's 3 major changes in the statute. There's the issuance of the warrant, the deportation defense, and then the possibility of remitter, and I'll take those kind of one at a time. The issuance of the warrant. The statute already requires the court to issue the warrant within 14 days. If it doesn't issue the warrant within 14 days of the failure to appear, that could be a defense that's used for forfeiture. And that's been in the law for, I think, maybe 5 years. Part of that was, because there was a few districts that were deciding that, well, we're just not going to issue a warrant until after the 60-day requirement has passed, and if you guys don't get him, it's on you, and then we'll issue a warrant. The legislature decided that, maybe we should be putting all of our efforts into getting this person back. And so to provide some teeth to require the courts to actually issue those warrants, if they didn't want to issue the warrant, they certainly didn't have to, but they wanted to pursue a bond forfeiture, they needed to issue the warrant. So there's two aspects of the surety needing a copy of the warrant. There's one, to be able to demonstrate the warrant is actually issued within that 14 days. Now, we could get around that if we needed to by subpoenaing the sheriff to come down and testify as to the specific date the warrant was issued. And so that's not probably the most important one. The more important one is many states now have bounty hunting regulations for if we go out of state to pick up someone who's missed court. California, Texas, and there's several other states that require you to check in, and Kansas has this check-in requirement as well. If somebody comes in from out of state, or even if we're trying to pick up someone in Kansas, we have to check in with the local police department, say, this is who we're looking for, this is where we're going. So, if something happens, if you get a 911 call, it is actually us, that's what's going on. It gives the police the opportunity or the option, if they choose to come along with you to apprehend that person, and they may not. But many states, if we go out of state, they want to see a warrant. And if we are not able to provide them a copy of the warrant, they don't necessarily want to rely upon a copy of the bond. So this would allow us to get a copy of the warrant. There is a change that we have proposed here, and this was in response to the opponents of this, was we don't want to create a situation where the court has to generate us a copy of every single warrant. So we've proposed putting in language on line 15 that says that warrant shall be provided to us upon request. That way, if we go to the clerk's office and we need a copy of the warrant, we can get that, but it doesn't create a mandatory scenario where the courts have to go turn around and send us out copies of warrants every time they issue. So it's only if we need it, we can go to the clerk's office and get it. So we're not creating a bunch of extra work for the clerk. The second issue is the issue of a deportation defense. Now, we did come in multiple years ago during the first Trump administration and try and create a deportation defense. It made it out of this committee, was sent to the floor of the House, and then unfortunately did not get above the line back then. Of course, as administrations change, enforcement priorities change as far as deportation. What the language in this does is provides a defense if the defendant was deported. Now, when this first went through the Senate, or first was introduced, the language if the defendant left the country. And that's probably not fair to sit there and say if somebody absconded from the country, we should be able to get off the bond. And so, and the Sheriff's Association suggested putting in the language that the defendant has been deported, and we support that. But that is still pretty broad. And so the suggestion we've made here change-wise is to put in language that says if we posted a bond and at the time we posted the bond, the defendant was not subject to an immigration detainer. So in other words, if we go up there and post a bond and there's nothing holding that person and they later on get deported, the immigration comes in and grabs them, then we have a deportation defense. However, if when we went up and posted the bond, they did have an immigration hold. And there might be times that you want to post that bond because there might be someone who has an immigration bond. They're going to be turned over to immigration. They can post an immigration bond and come back and resolve the case. But you are taking a risk that they're going to be deported. And we don't think it's necessarily fair to say, well, we should be able to collect this money, let that person walk out the door, or not walk out the door, but get turned over to ICE, get deported, and then we don't have to worry about it. Our concern is if we are not aware that that person is going to be subject to deportation and then ICE comes in and grabs that. So the changes we've made, suggestion on line 2, or I'm sorry, on page 2, basically make that explicit, if the defense of deportation. Now, and the third section in here is the remitter section. The statute as it stands now allows the court at its discretion to remit some or all of the bond if the surety gets that person back in after a judgment's already been granted and paid. Some districts have more lenient policies. Sedgwick County, for instance, has a graduated refund schedule. If you get them back within a certain period of time, you get a certain percentage back. If you get them back within a longer period of time, you get a lesser percentage back. But there's no statewide standard for how that should be done. It's all simply court's discretion. And there are some districts that are very lenient about it, and there's some districts that are like, I'm not giving you any money back. I don't care what your defenses are. I don't care what the arguments you make. I don't care if you can prove to me 100% that justice requires a remit of this forfeiture. I'm not giving you anything back. So what this does is creates a mandatory remit procedure where there's some degree of refund. Now, the language that came over from the Senate shows 95%. That's a pretty high amount. And I know that the Sedgwick County District Attorney's Office really didn't like the 95%. So on page 2, we have in red on my testimony, actually not page 2 of my testimony, but page 2 of the bill, and I've attached these to my testimony. We have created a graduating descending scale where if you can get the person back within 90 days, you can get a 90% refund. If you get them back up to 180 days, it'd be a 75% refund, and out to 270 days beyond that, there's a possibility of a 50% refund. Now, I understand there's going to be people that think that that's too high, and I know that Mr. Breitenbach, I think, was very concerned about the 90% or the 95% level, and I think he was more comfortable with the 90% level. But what it does do is it maintains an incentive for the bonding company to go back and get that person. So if we go chase that person down and, 60, we've already had to pay the bond forfeiture off, we're probably not going to put a whole lot of effort or expense into getting that person back in if there's no possibility whatsoever we can get that person back in. And if there's no possibility we can get any sort of refund on that, it may not even be legal for us to pick that person up. There's some case law that says the only basis we have to legally apprehend someone is for resolution of the forfeiture. If that forfeiture is already paid and there's no possibility for remission, it might not even be legal for us to pick that person up. So putting these in place gives a statewide standard for what that remission policy should be. And with that, I'm happy to answer any questions.
Committee, do you have any questions for Mr. Rolfe? Representative Barrett and then Vaughn.
Thank you for coming to committee. I guess my question would be the 90, 75, and 50. Where do those percentages come from? Is that from another state, or was that just what seemed fair in your eyes?
No, there are other states around, like for instance, the state of Oklahoma, just south of us, has two 180-day periods. Basically, you can go back in after 180 days and ask for that to be extended again. So up to 1 year in Oklahoma, you can ask for 100% back. Every state has a different policy on that, so these aren't coming from any place in particular. I think they're an expansion of the policy that Sedgwick County has. They have a 75, 50, 25% policy over a period of time. And so this obviously is more generous than that procedure, but that's, yeah, there's nothing, we haven't borrowed that from another state.
Thank you, Madam Chair.
Representative Vaughn.
Thank you, Madam Chair. I think I actually answered my own question. It was in regard to the first suggested amendment about adding upon request and where that would actually go. So the desired change, so already under law, a copy has to be provided to the National Crime Information Center within 14 days, and you just want to add that upon request, a copy should also be made available to the compensated surety who deposited the bond. Is that correct?
Yeah, so we can't go up and get every single warrant that the court might have issued. It would only be cases where we were actually the person on the bond that had posted that, and it would be upon request, so we're not creating a situation where the court has to generate an extra copy of the warrant and give that to us in every single time someone misses court, because it's not necessary in every single time.
That helps. Thank you.
Okay, committee, do you have any other questions? Representative Osman.
Thank you, Madam Chairwoman. I have several questions. I'm trying to get sort of a holistic view of the situation as it relates to bonds. So when somebody is seeking your services, typically, like, is there any sort of, what information do you secure from them to obtain them as a client? Is it just they have paid X amount of money, therefore they are your client? Or is there any sort of a background check or any sort of documentation that is part of the procedure?
Yes, Representative Osmond, thank you. That's going to vary from case to case. Obviously, if we're talking about a deportation sort of situation, we're in the kind of uncomfortable position right now that everyone with Hispanic or African sounding name, you're like, okay, what's your immigration status? Which is embarrassing for us and them both. But sometimes it's a situation where you're going to need to provide us something. If you have a green card, we're going to need to see that. If you don't have any paperwork at all, we might walk away from that completely. We're also going to get what we refer to as an indemnitor or a guarantor on the bond, which generally means a friend, family member, some member of the defendant's community support network to come in and make that guarantee to us. And so obviously, if the person's in custody, they're going to be limited in their ability to provide a certain documentation. So, I mean, we can rely upon the information that they've provided to the jail, but we aren't necessarily going to see that from them. So a lot of that, we're going to rely on their friends and family member to kind of fill in the details. Some of those things are lies. I mean, I don't want to get into story time, but we just received a W-2 from someone today that was clearly false. I mean, you're going to guarantee this bond. We want to see that you have a job and you've had a job for a period of time. And they indicated that their wages were $18.95 for last year, but they made $168,000 in Social Security benefits. And it's like, that doesn't match. I mean, and there are programs out there that people can use to falsify these sorts of documents. So the direct answer to your question is it changes with each case. We're looking at different situations each case, how serious the case is, what's the likelihood they're going to serve time, what's their connection to the community. Lots of different factors go into how much information we need. And we may require a lot more information from one person than another person just because we may have had this person on bond 5 or 6 times before for various traffic offenses or whatever over the years. So we're quite familiar with them. They've been a member of the community for a long time. I'm probably not going to want as much information from them as I'm going to want from someone who I've never seen before, who's never been booked here before, might have an out-of-state address. I'm going to want a lot more information from that person.
Thank you. And I wanted to try to find out from the flip side of things. So somebody's arrested, somebody is charged, they go through a bond hearing itself. At any point in that process, is identification obtained? Is citizenship determined before they approach you as a client?
Well, right now, I don't know that there's any citizenship determination. I know that there's a bill that's working its way through the Senate that would require, and this was something that the Attorney General's office introduced, that would require the arresting agency or whomever, the court or the arresting agency, to confirm your immigration status. If you're a non-citizen, you know, that immigration status has to be confirmed before or at the time the bond is set. So there is nothing about that yet. Now, I know from a practical standpoint, back in the day, I don't know if that's still the case, but during the first Trump administration, I know that Johnson County's policy on that is if you listed that you were born outside the country, they would send your name over to ICE to see if they wanted to put a detainer on you. Now, I know there's been some changes in the law since then, so I don't know if they still do that. The Sheriff's Department and the arresting agency, they're aware of these situations, and they do their best to try and get that information. It's not always accurate. I don't know if that answers enough or if there's a follow-up that...
Just if I would, one last question. I'm just trying to figure out, comparatively, how often is this a problem under current circumstances? How often are your clients or the clients within the industry deported before trial commences?
A lot of that, sorry, Representative Osman, a lot of that depends on the stance of the federal government and how aggressively they want to engage in enforcement. Now, obviously, we're going to adapt our behavior to the enforcement level of federal government. If they're going to be a lot more aggressive about that, we're going to, change how we post bonds. As far as raw numbers, the best number I can tell you, and this is, I was doing some research for this other bill that the Attorney General entered. Over the last 6 weeks in Johnson County, I went through all the releases in Johnson County and looked at everyone who was released with an ICE detainer. And that's really the only way we have to tell, and there were 21 total cases that were released with ICE detainers. 12 of those cases were released on sentencing. 9 of those cases were released pre-trial. 7 of those pre-trial releases were signature bonds. It's for whatever reason the court decided, no, we'll just let you go and then turn them over to ICE. I think that's a situation, in answering your previous question, the court was probably unaware that they had that detainer. They may not have given them that signature bond to be released. The 2 remaining ones, one was a cash bond. That defendant has posted the cash, turned over to immigration, posted an immigration bond, has been back to court. The last one was the surety bond, and I have no idea why that surety, wasn't me, posted that bond, that person has already missed court, and now that surety is going to be subject to forfeiture. Now, he would not be protected under the language we've proposed here because there was an ICE detainer in place at the time.
Representative Schreiber.
Thank you, Madam Chair, and maybe with your indulgence, I could circle back to the question I had with Senator Owens about the impact of last year's bill 473, and and you'd mentioned that originally in your testimony on 244.
Yes, thank you, Representative Schreiber. I may not be the best person to answer that. I work primarily out of Johnson County and Wyandotte County on the eastern side of the city. We did not have a problem with this to start with. This was largely out of Sedgwick County. The information I was basing that on was what we'd heard from other bonding companies in Sedgwick County and from Mr. Breitenbach's testimony on the House side, that this was working, that they were seeing bonds come down. So the total impact, I'm not quite sure how you would measure it, but the district attorney's office there seems to think it's working.
Okay, any other questions? Representative Carmichael.
Thank you, Madam Chair. Mr. Rolfs, in your written testimony at page 3, the first full paragraph discusses the proposed amendment that is also, I believe, attached to your testimony in red line form. And if I look at that proposed amendment at page 2 of the text, down about line 35 through 40, there is a sliding scale based upon time and the amount of the bond that would be refunded to the surety. It goes on a schedule 90%, 90 days, 75%, 91 to 180 days, 50% within 181 and 270 days. What happens after 270 days?
In theory, you know, the
I
statute
mean,
still.
I understand the premium or the amount at risk is
Right.
less, and at some point there's a real declining incentive for the bond person to go out and locate the defendant.
Right.
But if you have a chance to make some money, I mean, what happens after 270 days? Is it a complete forfeiture?
I would assume the statute still allows for you to petition the court and give some reason why you should do that. But I think in practice, what you'd see, if this amount of time was mandatory, courts are going to be far less inclined to give you anything back after that period of time. The language in the statute does still allow you to petition the court to make that determination.
And if I might follow up, given that the amount is discretionary after 270 days, I suppose that would mean, well, you could only get 50% back on the 269th day, then the court might have the discretion to give you 100% back on the 271st. And that doesn't seem to follow to me.
I think the court still retains the ability to refund 100% at any time. If you didn't make that, if you just went to the mandatory requirements, then yes, so you go with at 269 days, you get your 50% back. But I would think if you had some really good reason, you could still go petition the court for 100% refund during that, whether the court's likely to grant that. And I think if you establish these guidelines, the courts are going to be less likely to stray from that in giving back additional money.
Sadly, I'm more confused now than I was before, but thank you.
Hey, committee, any other questions? I do have a quick follow-up question to that. So now do you find when you petition the court or others petition the court after, say, 90 days or 180 days, is it common that you would get a portion back, or does it depend on the reason, or sort of tell us a little bit about how that plays out in actuality?
I've gotten 4 partial refunds in the last year. One of those was from Johnson County, and we managed to get the guy back in, I think, a week after judgment was granted. And so the court gave back 100%. The other ones were out of Wyandotte County. Wyandotte County's remission policy is if you can get them back within 30 days from judgment, they will give you back 66%. And there were 3 of them that we had there. And we've been told in no uncertain terms, don't even bother asking after the 30 days is up, because you're not going to get it.
Okay. Okay, thank you. Committee, anything else? Okay, thank you so much. We appreciate it, you being here, Mr. Rolfe, and I'll now call up our second proponent, again, Senator Owens.
Thank you, Madam Chair. Thankful to be back, and I'm thankful to have the opportunity to work with all involved parties on this. I think it's worth noting, if I'm correct, originally in the Senate version, both the Sheriff's Association as well as the Sedgwick County District Attorney were in opposition. These changes reflected in that possible amendment, if the House sees fit, brings the sheriff to a proponent, if I remember correctly, as well as Sedgwick County to a neutral on this. And so this really was just working with all parties involved to find a compromise. I will call out my own mistake before someone else does, and that is, oops, sorry, am I pushing it off? Okay, thank you. I made a mistake in mine on line 37 at the very end of the proposed amendment, and still have 95% under I. That should be 90% to match Mr. Rolfe's testimony. So this actual sliding scale was the recommendation of Sedgwick County District Attorney's Office, and that's why we stuck to that. Speaking to anything after the 270 days, I think the assumption is that you don't have the option after that. Judge certainly could still grant it because they have that discretion, but I think the assumption was that after that period of time, that it would be 0. And I'll stand for questions.
Okay, thank you. And I do think you're correct in that in our agenda and from the committee assistants that we do have proponent written only testimony from the Kansas Sheriff's Association, and then neutral, we will hear from Aaron Breitenbach on WebEx after we're finished with the proponent. So then we'll know about that. So, okay, yes, committee, any questions for Senator Owens? Representative Carmichael?
Thank you, Madam Chair. I apologize, Senator. I wasn't quite following. You're saying that on the red line copy that down at line 37, sub I, instead of 90%, you're wanting 95% returned?
No, just the opposite, sir. In my testimony, I have 95%, and it should be 90% to match Mr. Rolfs.
I'm on track now. Thank you.
Okay, anything else, committee, for Senator Owens? Okay, thank you for being here. We appreciate
For the
that.
opportunity. I miss you guys immensely.
We miss you
That is
too.
the truth. Thank you.
Yeah. Okay, committee. Again, I mentioned that there is written testimony proponent from the Sheriff's Association, and now we will hear neutral. So Cole, do we have Mr. Breitenbach on with us? Okay, great. Can you hear us?
Yes, I can.
Okay, thank you. We can hear you. We can't see you yet, but hopefully you'll be there.
Can you still not see me?
Oh, there you are. Okay,
Okay.
yes.
Sorry.
Okay, thank you. Welcome to committee. If you'll introduce yourself, and appreciate you being here with us. Thank you.
Thank you, Madam Chair. I'm Aaron Breitenbach from the District Attorney's Office here in Sedgwick County. Appreciate the opportunity to appear remotely very much, as I mentioned yesterday. As was mentioned by the proponents, in the other chamber, we had a much different tone because the original language permitted a lot of things that raised a lot of flags. But I want to extend some appreciation to the proponents for their willingness to work this bill with us to address those. And I think that what they have given you with their red line that submitted in Mr. Rolf's testimony in particular captures what the language that allows us to move to this neutral position. I stopped short of it being a proponent because I guess I kind of feel it's their job to make the pitch, right? But if this is to move forward, I believe that they have addressed materially and significantly our concerns to the point that it would be good policy. In particular, on that first point, as has been talked about, only making the warrant due upon request. A couple of just inside baseball things to understand. First of all, generally warrants can't be released. There's a statute that prevents, the release of warrants. So even if a clerk wanted to, right now they wouldn't be able to. Further, until a warrant is executed, that warrant is sealed in Odyssey. And so it's not something that's available generally, at least in some cases, I guess I should say it's sealed. But there are reasons why it would be hard for the sureties to get these documents without the statutory language. I also wanted to acknowledge and appreciate that they, on page 2, made it again clear that the document did not have to be provided within 14 days of the issuance of the warrant, because again, in most situations, they're not going to ask for a copy within 14 days. They're going to ask for it 2 weeks or 2 months, 3 months, 4 months later when they find him in Oklahoma, and now they need a copy to go apprehend them. So that was a good clarification. I also appreciate that they moved the immigration defense, detainer defense to an entirely different subsection, just so there's no confusion between it and other defenses that previously existed. One remaining, what I would hope is a relatively minor area of disagreement. In my written testimony at the bottom of the first page, I am proposing the potential, and the question was asked, who regulates this? Who enforces this? In our jurisdiction, it falls largely upon our office. The investigation would be done by the sheriff's department, but our office is the one who files the forfeiture and litigates the enforcement of the forfeiture. And if someone is violating the rules, we're the ones, to some degree, that have to make that case. The court can't make the case to itself, right? So that's kind of our role in this. What I would ask, and I'll just briefly, I guess, read it, is to have the ability that if we could show evidence to support this language, that the court shall not set aside a forfeiture under this subsection if a preponderance of the evidence establishes the surety or bail agent acting under the authority of the surety knew an immigration detainer was imminent or otherwise knew a defendant was subject to removal by the United States when the bond was posted. What I'm talking about here is having to prove actual knowledge. So not negligence, they relied on a faulty green card or whatever, but, without, again, doing too much story time, there are, jail calls are recorded. And our jailers listen to those, and you'd be surprised the conversations that happen when these bail contracts are negotiated. And sometimes they're insightful. I'll just leave it at that. But if there were a situation whereby that means or some other, we could show that a surety or their agent was really acting in bad faith when they signed that bond, I would like the ability to present that evidence to the court. And if the burden is beyond, preponderance of the evidence, more likely than not, to allow the court to still enforce that bond. Again, if you're asking me how often I expect that to happen, let alone be able to prove it, I can't give you a number. It's just that I've never had to litigate this before, and so I'm trying to see forward what issues I may want to raise if we have to litigate it. And so that's why I asked for that language, if you would permit it. And then on the final issue, and I'm sorry, before I leave the deportation, it may seem odd, or some of you may wonder to some degree why we care, right? You may think, well, sure, there's an immigration hold, so if they post the criminal case bond, the ICE hold will keep them there, and you still get to prosecute your case. Well, that may very well not be true, because once that immigration hold kicks in, and if it's the only thing holding them, then it can set forth processes and clocks and things on the immigration side. Sometimes, depending on the case, the immigration authorities will listen to our office on how quickly they litigate or handle a removal proceeding. But then there are some times that they don't, and we may have victims who never get accounted for, never get their case heard, and that is an interest that we have that we seek to protect, and to not allow people to get bonded out and trigger immigration releases faster than what would otherwise happen. So just in case that was a curiosity in people's minds. Now, to the last issue, the remittal, as has been shared, I did have concern about what passed out of the Senate, which was the 95% 180 days. As I explained in my written testimony, the reality is, assuming the clock is followed as quickly as possible, person fails to appear today, there's then 60 days before, and let's assume we file the forfeiture action, right away. There's then 60 days, and it's only at that point that the court can then declare, a forfeiture, and then there's still another 30 days, awaiting that judgment, and then perhaps additional time to pay on that judgment. So there's some baked in time that you can lay on top of any of these periods of time. And so especially when you talk about 270 days, you're really talking at least a year since that person failed to appear in court. And I agree with proponents. I would like to think that absent some exceptional circumstances, that our courts will likely not remit anything at that point. But if they wanted to, if the bondsman could demonstrate that they went through, Herculean efforts to bring someone back, then they can make that case. And to perhaps help Representative Carmichael's concern, again, these numbers are not caps. So what it's really setting is the floor. At 90 days, the court must give 95. If the surety can make a great case, they might get 100. Or at 91 days, they might get 100. They have to get at least 75, right? So these are all basically setting the floor of recovery. In my written testimony, I shared that in Central County, it's very much compressed. It's 75% within 30 days. It's 50% between 31 and 60, 25 between 61 and 90, and after 90 days, you got to sing for your supper. But I have since been educated on what the market is in the surrounding states, and I appreciate, you know, the need to be more consistent across the industry and perhaps for other reasons. So these percentages were essentially kind of a negotiated agreement where at these, over this period of time, at these percentages, I believe that we still incentivize them getting the person back sooner, which is my primary interest, while also keeping a carrot in front of the surety to pick them up, relieving some of the burden on the law enforcement and the sheriff to go find all these people. Still keeping that carrot to keep that work going so that more people are working to bring that defendant back, which again serves our interest in prosecuting the case as quickly and efficiently as possible. That's a lot of talk for neutral testimony, but I appreciate the opportunity to be heard and would be happy to answer any questions that you have. Thank you very much.
Okay, thank you. The committee, you have questions for Mr. Breitenbach. Lindsay, Representative Vaughn first. Then
Thank you,
Carmen.
Madam Chair. Thank you, Mr. Breitenbach. I had a question about the remittal schedule. I was looking through your testimony and I found it interesting that Sedgwick County has the compressed schedule. So under 90 days, the bill originally included a 180-day period, albeit without a schedule, just the 95%. And then this suggested amendment is a 270-day schedule. So, I mean, those are all just, I mean, fairly different. And so I guess I'm wondering, you know, how did everyone land on the 270-day schedule? How did those percentages, how were those chosen? And then it sounds like, you know, perhaps there's discussion about what other states do, but I'm kind of curious if you're aware of what other, some of the other major counties in the state do, if they follow a similar process, if it's closer to the 90 days or the 270 days. Just curious for some additional insight into that recommended schedule.
Thank you very much for the opportunity to talk about that. I will admit I am not well versed in what many counties do. I am aware that other counties have schedules like this. I had heard about Wyandotte County. I don't know how many have stair steps and how many are more than 30, 60, or 90 days. That level I don't know, but I do know that variations on a theme exist, and they're all up to the chief judge, right? As was shared by the proponents, the chief judges set the local rules, and that's generally where these things get hammered out. As for these particular numbers and kind of how we got here, well, first let's start with that distinction between 90 and 95 that kind of came up here. It was important to me that a surety that failed to get someone to court within 90 days, you know, which is the normal forfeiture execution time window, and then add more time on that, whether it's 90 days, 180 days, whatever it is. You know, this is someone who has fundamentally breached their contract with the court to get someone to court on time. Well, if you go back to the other bills that we've talked about, the sureties are supposed to get at least 10%. So they would potentially be profiting from a contract that they broke. And that really rubbed me raw. And so I kind of insisted that whatever maximum minimum remittal is going to exist needed to cap at 90. So that's kind of, I can explain that number because I insisted on it and that was why. And then as far as how we got this gradation of time was, again, the bill as passed by the Senate was the 180-day milepost, and I shared Wyandotte's, I don't know what county I'm in, Sedgwick's gradation as a way to maybe straddle that line and meet in the middle, right? If I'm not comfortable at 95 or 90% at 180 days, maybe I could see at 90, I'll meet you somewhere at 180. I'll even, and then as part of process, I'll give you more time than you were even asking for but at a lesser percentage. So kind of I'm not a legislator, but this process probably does not sound foreign to you. That is how this discussion went. And like I said, you're right. In Central County, that timeline, that gradation was set by our chief judge. I'm not here to say that there's anything wrong with what we're doing in Central County, but I've since learned that there are other ways that things are done. And since I'm talking about statewide policy, I believe this strikes a balance, particularly compared with what came out of the Senate.
Representative Carmichael.
Thank you, Madam Chair. Mr. Breitenbach, I always appreciate your insights and your help. I hope you're still there. We just lost you on the screen.
Probably to your benefit if you can't see me. So,
well, I'll still go ahead and ask my question. I do appreciate your explanation that the the scale that we see in the proposed amendment represents a floor. But now that raises a different concern, because if those numbers are just floors, I can imagine a situation, certainly not in your county, but in counties where there are partisan political selection of judges with campaign contributions from bail bonds people to those judicial campaigns. If those numbers are floors, could we find ourselves in a situation where some judge someday just gives 100% refund after 90 days, 180 days, 270 days, that just as a matter of policy decides we're going to treat the bail bond industry well, they've treated me well in my campaigns?
well, I would never suggest that our judges would do anything contrary to their ethical canon. So, and I know you are not either. But I would say this: that can happen now. Not saying it does, to be clear, but right now it is purely judicial discretion. There's no floor, there's no ceiling. It is whatever a judge wishes to do. And I'll be honest, I don't know what standing the state or anyone would have to appeal. So it is a purely unchecked process to the extent your concerns could occur. I believe that we have this type of a gradated situation in Central County. And what it primarily does is it just provides clarity, right? Instead of having to litigate these, because it is not uncommon that a judgment gets entered and paid, and then 2 weeks later they find them. Well, I would much rather that surety be able to just submit paperwork, the clerk knows to give them X% back and it's done, than have to have a evidentiary protracted hearing where we're going to have to fight through, well, today is it 85, is it 92, is it 76? Having a set schedule provides clarity to the surety industry as far as risk allocation and things like that, and it really provides efficiency to the court system because they don't have to litigate it. They don't have to do all this weighing of what manifest, justice requires and things like that. They can just go to the statute or in our case, the local rule. And candidly, I agree with the proponents. I think if you give them numbers, the courts will follow numbers because they have a lot of the things on their docket, and litigating these is not high on the list. So give them guidance. I would expect they will follow it. They have the discretion not to, and there are valid reasons for courts to have that discretion. But I do think that having some version of this statewide, candidly, again, to your concern, provides a hedge against that because then you have less variation district to district, courthouse to courthouse. So that's my thought.
So, Madam Chair, my second and follow-up question would be, how could this be a ministerial task by the clerk to simply look at the schedule if these numbers are not caps? They're not absolutes, they're merely floors, and there is supposed to be an exercise of judicial discretion. How can you then have a court, or how can you have a clerk exercising that discretion?
Well, again, I think, and I appreciate the opportunity to answer the question. I think it depends what the ask is, right? If the surety knows the schedule says 75%, they're going to ask for 75%. They're not asking for a hearing to get something above what the schedule says. They're just asking for what the schedule says. And so that's how it is ministerial. At least that's how it works in Sedgwick County. But I suppose if a surety in Sedgwick County wanted a higher percentage, they could file a motion and seek that hearing and that judicial discretion to be applied. But we haven't seen that. And again, I think it's because they kind of know what they're going to get. The judges told you through the local rules what you're going to get. And perhaps, if this is a concern to the group, to the committee, I should say, then maybe these need to be the percentages, right? They're the floor and the ceiling. But I'm not proposing that amendment because A, that's not what I'm here to do, and B, I have experience with how these things work in Sedgwick County, and I think the proponents are correct. If you put these numbers in, this is what they're going to get, and everyone will assess their risk accordingly.
I look forward to continuing our discussions in an informal forum. Thank you very much, Mr. Breitenbach.
I always look forward to that. Thank you, sir.
Yep. Okay, committee, any other questions? Okay, thank you, Mr. Breitenbach. We appreciate you being with us, and that was helpful. Okay, committee, no, well, that's the only neutral testimony. I'll now close the hearing on Senate Bill 157. I do appreciate everyone staying awake and attentive because this is a lot of legal stuff, and y'all have really, it seems like, come to embrace this, the committee. I appreciate that. Okay, committee, as I had mentioned earlier, we will work bills tomorrow. I'll let you know bills that I intend to work. It may not be that we can get to all of them, or we may have a hiccup with one of them, or you know how that happens. But I'll give you a list of the ones that I think we might work. Okay, first of all, we will have a hearing on Senate Bill 222. And then the bills that I would like to work are House Bill 2131. It's the jailhouse witness bill. House Bill 2349, which deals with scrap metal. House Bill 2173, which is the opportunity to petition to get off the offender registry if you were caught in that retroactivity. Those are the three House bills. The Senate bills are Senate Bill 84 that had to do with gift cards. Senate Bill 53, which had to do with law libraries. Senate Bill 71 that we heard on Monday that was upping the penalties for buying sexual relations. And Senate Bill 138, which had to do with search warrants, and we just heard that yesterday. And Senate Bill 135, which we also heard yesterday, that it was from the Sexual Assault Center about PFAs. Okay, those are the ones that we might get to tomorrow that I would like to get to. Yes, question, did I? Yep, go ahead, Representative Vaughn.
Thank you, Madam Chair. I was thinking we passed out House Bill 2173. Did it get sent back to the committee? Or?
Oh, yes, it did get sent back to the committee.
Okay.
It was below the line. We passed it out, and it was sent to the calendar committee and then sent back to Judiciary. I do think there might be some amendments to it, and so it would be sent back here. And we'll just have to see how that plays out tomorrow, but I'd like to get that passed out again. Yes, Representative Martinez.
Thank you. Could you repeat the Senate bills again, please?
Yep. 84, is it okay if I just say the numbers? 84, 71, 53, 135, and 138. Okay, anything else for the good of the committee? Okay, thank you, everyone. We're adjourned.